Okay, after performing my own outside research, what more did you learn on this topic issue? Please indicate your outside reference. So, according to the KFF, which is an insider to women's health policies, news, anything like that. So, since 1977, the Hyde Amendment has banned the use of any federal funds for abortion, only allowing exceptions to pay for terminating pregnancies that endanger the life of the pregnant person or that result from sexual assault or incest. Among the 36 states that do not ban abortion, 19 states and D.C. follow the Hyde Amendment, and 17 states use state funds to pay for abortions for women with low incomes insured by Medicaid beyond the Hyde limitations. Today, 35% or 5.5 million of women's ages 15 to 49 covered by Medicaid live in the states where abortion remains legal, but the program will not cover the service except for limited Hyde circumstances. 21% live in the state where abortion is banned. Medicaid is a significant source of health coverage for women who have higher rates of abortion in the U.S., including women with low incomes and women of color. The overturning of Roe v. Wade has limited abortion access in large swaths of the United States, but for many individuals, especially those with Medicaid coverage, access to abortion services was limited prior to the Dobbs decision. Since it was first enacted over 40 years ago, the amendment has been sponsored and supported by legislators who oppose abortion and object to the federal government's use of taxpayer money for abortion services. The policy is not a permanent law, but rather has been attached as a temporary rider to the annual Congressional Appropriations Bill for the Department of Health and Human Services and has been renewed annually by Congress. What are the regulatory and or legal implications of this topic and issue for hospitals and providers? Not long after the Supreme Court's 1973 decision establishing a constitutional right to abortion, Congress enacted the Hyde Amendment, which prohibits federal funding for abortion except in cases of sexual assault, incest, or endangerment of the pregnant woman's life. Hyde also limits federal abortion funding under the Children's Health Insurance Program, Medicare, and the Indian Health Service. So, this amendment has been renewed annual ever since, and its funding prohibits has been broadened beyond the initial focus of Medicaid coverage. In 1980, a divided Supreme Court upheld the constitutionality of the Hyde Amendment. Writing for the majority, Justin Potter Stewart reasoned in Harris v. McRae that a woman's constitutional right to reproductive choice did not include a constitutional entitlement to the financial resources to avail herself of the full range of protective choices. And then because poverty is not a suspect classification, the funding prohibits did not violate the Fifth Amendment's Equal Protection Clause. The four dissenting justices disagreed, arguing that by funding the expenses of childbirth and prohibiting funding for medical necessary abortions, the federal government was denying equal protection to low-income women and effectively coercing them to choose continued pregnancy and childbirth, contrary to their wishes. Justice Thurgood Marshall, the Supreme Court's first black justice, wrote a notably impassioned dissent. So then a district court judge had ordered TRICARE to cover the abortion costs, and the judgment appealed to get its money back and assert a precedent for the limited scope of federal abortion coverage. So with that, it didn't bring me any questions. And then I have done research on insurance policies in previous classes, but abortion has always been a hard talk about in any sort of healthcare class. But it's something that I have also been super passionate about.